Welcome to Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching a miscellaneous criminal felony docket day. Now, on this miscellaneous day, it's going to be split into several parts, and this is a new change for 2023. In the mornings, we're going to have smaller violations of probations, maybe some smaller hearings, things like bond hearings where maybe somebody's stuck in jail. Otherwise, you're going to see people who violated their probation, most of which are going to be in jail because violations of probation are not granted a bond automatically. So you're going to see those kind of hearings where bond hearings, or people who are admitting or denying that they violated their probation. Now that's the morning segment. In the afternoon, and this is the new change, for 2023 we have felony plea day. Now this is, some places call it arraignment. This is going to be the first time that people have gone into court. Now these are going to be people who have not hired a private lawyer at this point. If they've hired private counsel, they're going to waive this arraignment date. However, people who have not hired a private lawyer are going to be there. They're going to be told what they've been charged with, and they're going to get the opportunity to let the judge know if they want to hire private counsel or apply for a public defender. Now, immediately following felony plea day is going to start the afternoon portion of the miscellaneous docket. Those are going to be your longer hearings and sentencings. Hearings like a suppression hearing where someone's trying to prove that maybe the police didn't do something right. These are going to be those hearings where you have witnesses, probably multiple witnesses. And then on the sentencings, you're going to have people who are asking the judge, give me a lighter sentence. The state's offered this. I'm trying to get something different. I don't want the state's offer. I don't want to go to trial. I know I've got a plea, but please give me what I'm asking for. And they're going to bring in those witnesses, like they'll bring the preacher, they'll bring their family members, the coach, someone to come in and say good things about them and maybe some mitigating things about them to justify giving them a lower sentence. So those are going to be mostly what happened in the afternoon. There'll be less of those, obviously, because they take longer, where the morning docket might have 50 people on it. The felony plea docket might have 50 people, and the felony plea docket goes rather quickly. This afternoon miscellaneous is going to have normally less than 10, and they're going to be the longer hearings, more detailed, more witnesses.
Michael Gilbert.
Good morning, Your Honor.
Good morning.
Your Honor, may I approach?
Yes. This is 22 CF 825, State of Florida versus Frederick Foster. Mr. Foster, you want to enter a no contest plea to the charge of grand theft, is that correct?
Yes, Your Honor.
Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God. Did you read and sign this plea and sentencing agreement form?
Yes,
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Did anyone force you or threaten you to enter this plea?
Oh, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Oh, Your Honor.
Are you happy with the work Mr. Gilbert did for you on your case?
Absolutely, Your Honor.
Okay, court finds the plea is freely and voluntarily entered. Court accepts it, sends you 2 years probation, restitution of $3,300. Early termination of probation upon completed payment of restitution, and pay a minimum of $150 per month towards that, $515 court costs adjudicated guilty. So if you get that restitution paid, and you haven't violated the law in any way, it looks like you'll get off probation. Is that correct, Mr.?
Sure.
Okay, well, good luck to you then.
Thank you, Your Honor.
Take care.
Yeah.
Your Honor, Tim Gibbs, Public Defender's Office. Judge, I had Mr. Foster on 24 CF 1291. The state had already moved to consolidate that into the case you just sentenced him on. So I just wanted to make sure the record was clear, because the order that I received, instead of saying 22 CF 825, the order said 24 CF 825. I did meet with Mr. Foster briefly. He confirmed that he was resolving his case with Mr. Gilbert today. I just wanted to make sure the record was clear that I do not have 24 CF 1291 anymore.
And the cases were exact duplicates. Same offense number.
It was just, he picked up, it's just a separate case number?
There was an old case that was directly filed on, and then for some reason there was a warrant.
Why don't you file NALPROS on the other
We've
case
already
number?
consolidated it.
Oh, okay.
The plea that the court just announced, or the plea and sentence the court just announced, resolves both cases, I believe.
Well, what I have is 22 CF 825.
Yes, the state moved to consolidate 24 CF 1291 into 22 CF 825, so
Okay.
they should all be covered.
All right.
Thank you, Judge.
Next case, Your Honor, covering for Christopher Crawford, Isaiah Drowsand, DRAWSAND, and 24 CF 370. There's a waiver on file. Mr. Crawford requests a continuance. I understand state will not object this time, but it'll be the last time.
August 26th.
That's all I have, Your Honor. May I be excused?
Yeah, thank
Thank
you.
you, sir.
Jeremy Keach. All right, go ahead.
Yes, sir. Your Honor, this is James Terrell, 21 CF 924, also 21 CF 1577. The case is on the docket today for a status update. There was an evaluation ordered, and Dr. Harper is to complete that. I do know that she has seen Mr. Terrell, but we don't have the written report yet. So if we could just reset it for another date for her to complete that report so we can determine the issue of competency moving forward.
You want to go to September 5th?
That'd be fine.
Okay, September 5th. Thank you. Is that you for finished for today? Did you do Evan Crawford's? Oh, okay. Evan Crawford's. Morning.
On behalf of Curtis Jones, F-24, CF-481, we have a negotiated plea with the state, but we will want to have it done in the afternoon calendar to have a written plea. And he has a...
Judge, Mr. Crawford has traveled from Miami, so the state is going to, we're going to draft up the plea agreement if we have a recess, and then we'll come back and resolve the case.
Who is the defendant?
Curtis Jones.
Curtis Jones. Okay, well, if you have a blank plea form, The public defender give it, go over it with him, fill it out, and so you don't have to wait till this afternoon. And we'll,
Thank you, Judge.
well, you got to have the plea form filled out and go over it with your client. When you get that done, let me know, and then we'll take your case, okay? David Rare. Mr. Hang on one second. Okay, go ahead.
Good morning, Your Honor. For the record, David Rare for Mr. Richard Van Rees, 20 CF 662. We're before the court on a motion for early termination of supervision. And Judge, do you have it alphabetical or by attorney?
I have,
If it's by attorney, Judge, it might be under Lupella and Rare, just Lupella.
I've got the case.
Perfect. We're before the court for a motion for early termination of supervision. He was originally sentenced to 5 years probation. At this point, as of this month, he's about 42 months of 60 months in, so he's at more than 2/3.
Where is he?
He asked to waive his appearance today, and I've waived his appearance today. We tried to schedule it out. Because of work, he wasn't able to be here in person. He also asked, ideally, not to continue the court date because we already had one scheduled. And so he asked me to proceed with the probation letter recommending early termination.
State?
Your Honor, Mr. Van Rees was placed on 5 years of supervision in January of '21. According to Florida State Statute 948.04, a defendant who's placed on probation or community control for a violation of charges under Chapters 827, which child abuse falls under, they are subject to the maximum level of supervision, and they may not be released early.
And Judge, I'm reading 948.04. That's a misinterpretation. To read the section that she's referring to, 948.041, the final sentence, a defendant who is placed on probation or community control for a violation of Chapter 794 or Chapter 827 is subject to the maximum level of supervision provided by the supervising agency, and that supervision shall continue through the full term of the court-imposed probation or community control. It is the level of supervision by state probation, meaning maximum level, medium level. How are they supervising him? It does not say it may not be early terminated at the discretion of the court. It says so long he is under court-ordered supervision, the agency, meaning DOC, must supervise him at their maximum level. His probation officer, Mr. Charles Becker, which is filed as a notice to the court, wrote a letter recommending that based on his conduct, how he has been during his period of probation with him, that he would have no objection to him early terminating at this point. All conditions are complete.
Well, Ms. Basso, that statute says it shall not be terminated early?
It says supervision shall continue for the full term of the court-imposed probation or community control. So if the court imposes originally 5 years, it shall be 5 years.
I don't have my statute.
Your Honor, I can just give you my copy, but it does have that part highlighted if
All right,
that's
let
not
me see it.
objectionable to Mr. Rare.
That's 2019. I want to make sure it's valid with the 2013. It should be the same.
What statute was he placed on probation under?
Under 82703, Your Honor, which was the child abuse charge, there was also a possession with intent to sell. It's the child abuse statute that falls under that, Your Honor.
Does it specifically say that probation cannot be terminated early?
The first line, Your Honor, says shall continue for the full term, and I'm paraphrasing, but it's the highlighted last line there. I believe shall means it.
Do I have any case law on this?
No, I was handed the statute today. I was not aware there was a non-early term provision that would apply to either of these charges.
Well,
This is a new assertion to me.
I'm going to deny the early termination without prejudice, so you can file, if you can give me some case law that shows me something different than what the state's arguing, then you can reset it. So at this
Understood,
time,
Judge.
I'm ruling denied based on the state's argument.
Understood, Judge. I've got a proposed order if you want to have that, or just...
Okay.
Shall I retrieve the statute?
Show you what?
I'll provide this back to the Judge.
I mean, I'm in favor of people getting off probation if they're doing good, but if I can't. if the
Right,
law
we can
says it-
file if we have some case law to address it,
Okay.
Judge. And that's all I have, Your Honor. May I be
All right.
excused?
Thank you. I know Mr. Berry wants as many people under his supervision as absolutely possible, so, you know.
Open for business, Your Honor.
Open for business, okay. Marty Nopes. Morning.
I've got Mr. Jefferson, who's present in the courtroom. Judge, we've been waiting on a report from Dr. Harper. I did get that last week. So if we could just have another date, I'm going to provide it to the state, the report.
How long you want to go out?
When's your next pretrial?
Well, it's August 26th.
August 26th? Maybe we'll...
We got an August 8th. We got a September 5th, August 29th.
They've got to be here August. Yeah, that's too quick. I won't have time to talk with him.
August 29th, how about that?
August 29th.
That's a miscellaneous day.
Judge, I can do that.
State has no objection.
All right, August 29th. And that person was, what was that person's name?
This is Aaron Jefferson.
Jefferson, okay.
Thank you, Judge.
Okay. Miss Flowers, I guess, or, yeah. Morning.
All my clients on today's docket are in custody. Okay. Where's Joshua? Your Honor, for the record, Jennifer Flowers with RCC for Christopher Cluster and 24 CF 1237. Your Honor, we thought we had a resolution for today, but I think we'd like to put it on for next Thursday, the 30th, for a potential plea.
Okay. July 30th. Thank you, sir.
Yeah.
Thank you.
And Your Honor, this is, for the record, Jennifer Flowers with RCC on behalf of Cheyenne Kristen Davis. This is case number 24 CF 1535. We've reached an agreement with the state, if I may approach.
All right. Miss Cheyenne Davis, would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God?
Yes, sir.
Okay, thank you. The State of Florida versus Cheyenne Kristen Davis, 24 CF 1535.
It's just one case.
You want to enter a no contest plea to credit card fraud, a third-degree felony, and petty theft, a first-degree misdemeanor, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers done on your case?
Absolutely.
Court finds the plea is freely and voluntarily entered. Court accepts it. 24 CF 153. Judge guilty. Sentenced to bars to bed, humble house, inpatient treatment. Followed by 3 years standard probation. All concurrent random UAs. 54 months DOC suspended. Reserve on restitution. No contact with victim. 515 court costs, 150 costs of defense, waive cost of supervision. In count 2, judge guilty, 11.29 months probation, concurrent, reserve on restitution amount. And judge guilty on both counts. Is that it?
Yes, Your Honor.
Thank
And I
you.
believe she entered this plea, she entered a plea to some other cases and then was arrested right after that plea on this older case. So this is a concurrent sentence with that case. And I believe it's just coming to my mind that in court that time that we started probation today so that we could arrange transportation to the Humble House.
Yes, Your Honor. Charles Berry with state probation. If we just go ahead and put her on 3 years probation with the condition to enter and complete Humble House, then she will start today, and then we can have her under our supervision the whole time.
All right, we'll do that. Any objection?
No objection.
And should I make this concurrent to any previous sentences?
Yes, Your Honor. That's the intention. Concurrent
Or I'll
with,
make it concurrent to all previous sentences. Okay? Thank you.
And that was 54 months suspended?
Yeah.
54 months.
Your Honor, this is Lawrence Rudd. I do not have the case number in front of me, but
24 CF 1196.
thank you, Judge. We're asking to put this on for 826 to track with his 2 new cases that I was recently appointed on.
Any objection?
No objection.
826. Thank you, sir. Keith Shanklin, 23 CF 2250.
Yes, Jennifer Flowers with RCC on behalf of Mr. Shanklin. Your Honor, we were unable to reach, again, an agreement with the state. We're going to have to put this on 826 to track with his other case.
All right.
And
All right, thank you, sir.
you.
826.
Yeah. They won't do anything.
Never mind. Take it to trial.
Okay. Your Honor, this is Darius Wilkes, 24 CF 1415, and we've reached an agreement with the state. If I may approach.
Mr. Wilkes, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, Your Honor.
Thank you. You want to enter a no contest plea to, battery on person over 65, a third-degree felony? Is that right, Ms. Flowers?
Yes, Your Honor.
Is that correct, sir? You want to enter that no contest plea?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Did anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers done for you on your case?
Yes, sir. I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty, sentenced to 30 days in jail. Consecutive to sentence in 24 MM 1946 with credit for time served. 515 court costs, $150 cost defense payable within 90 days release, then to collections. So
Thank you so much.
30 days.
All right.
Hopefully you've done them all, okay?
All right. Y'all have a
Okay.
good day in here. Thank you so much.
Thank you. And that's all I have today, Judge, if I may be excused.
All right, thank you. Evan Crawford.
state.
Okay. Yes. Thank you. All right, State of Florida versus Curtis Jones, 24 CF 481.
Yes, Judge.
Now, is he entering a plea to possession of a controlled substance? Is that correct, Mr.?
Correct, Judge. State will dismiss the other charges.
What is he pleading to? Possession of a controlled
Just
substance?
possession of controlled substance. I believe there's other charges. There's a driving charge.
Yeah, driving license suspended, resisting an officer without violence, fraud, impersonating false ID to a LEO and narcotics equipment.
Yes, Judge. The state, per agreement, is going to no-pros or null-pros those counts. And the agreement is just a plea to the controlled substance for the probation, and so withhold as well.
What
And
is-
if I forgot to sign that agreement, forgive me, Your Honor.
What is the, something, Mr. Crawford has written, something about, what's child abuse on here, count?
That's
That's the one that's no-pros.
No-pros
It was
by
never
state.
filed on.
Okay.
Judge.
So, but in this case, counts 2 through 5 are going to be dismissed, right?
Yes, Judge.
That's correct, Judge.
And then he's pleading to possession of a controlled substance, a third-degree felony, is that correct?
Correct, Your Honor.
Okay. And so counts 2 through 5 are dismissed. And, okay.
And he has a capias for a failure to appear, Judge.
I'll ask you to lift the KPS, because he didn't get those.
I'll withdraw it. What's the adjudication? Withhold?
Yes.
You fly up here from Miami?
Grove.
Grove? Come back, we need good lawyers up here.
Yeah.
This looks like you did a
the
good
defendant
job.
is a resident, defendant's a resident of Texas. He would like his probation transferred to the state of Texas, please.
All right. All right, Mr. Jones, would you raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, Your Honor.
You want to enter a no contest plea to possession of a controlled substance, a third-degree felony?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Say it again?
Are you aware of the rights you're waiving by entering this plea? Right to a
Yes.
trial?
Yes, Your Honor.
All other rights too, but did anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work your attorney, Evan Crawford, has done for you on your case?
Yes, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it. Withholds adjudication, puts you on 1-year probation, 615 court costs. There's probation right there.
Thank you, Your Honor. That's it?
Okay?
Request the supervision please be waived, Your Honor.
Yeah. Who was,
That would be Mariah Isaacs, Judge. It's a
Mariah.
competency hearing. We have a report back. I think we're all stipulating to the
she was
admissibility
incompetent,
of the
if I
report.
recall, correct?
That's correct, Judge. So if you could make a finding based off the report, the state stipulates to that report. And
Let me see that. She was the one that liked to use a lot of bad words.
Concerned about the situation with her child. and why the child cannot be placed with her despite her being incarcerated.
Okay. Bring her out. Where's she on the docket?
She is on the AM docket.
She is, Judge. She, on mine, I've got her at 41.
All right. This is 24 CF 556, State of Florida versus Mariah Isaac. Go ahead, Mr. Williams.
Judge, we had her evaluated. The defense and state have stipulated to the report from the evaluating psychologist, and I have provided a copy of that to the court. The psychologist was Stephen Zeman.
The state stipulates to Dr. Zeman's.
Yeah, the state has, the court's has reviewed the evaluation, finds she's incompetent to proceed. Committed to Department of Children and Family Services to restore competency. Is that,
Yes, sir.
all right, would you please send me an order?
Judge, I believe we might already have done so. I'll check on it. If not, we'll get one to you.
All right. Thank you. Thank you, ma'am. Hopefully you get better. Here's this report, Mr. Williams.
Sure. I don't know if the clerk puts one in the file or not. I haven't. That's, my legal assistant handles that. That's above my pay grade. I have to defer to the expert.
Do you have anybody here that doesn't have an attorney out there? Milton, come on up.
Ms. Middleton is back before the court for failing to pay court costs and failure to complete 50 hours of community service work. I supervised Ms. Middleton for a long time previously. The court costs was in each additional case number. We're good with placing those to a civil judgment, waiving the community service work, and terminating her supervision. She's completed everything else.
What about that, State?
The only change would be asking for the community service hours to be converted to a fine and go to collections.
All right, we'll do that, and the amount that she owed will go to a judgment and terminate her probation. Oh,
What about the $10 an hour on the community service?
yeah,
I think it's 13. About the change. It changes every September.
whatever it is, I'll convert that to, instead of her doing community hours, I'll convert it to monetary and turn it into a judgment so you don't have to do the community hours. You okay with that?
Yes, sir.
Okay. Terminate probation. And you had a lot of,
Judge, I'm showing Jesse Lee Howell as pro se. I only bring it up because that would be in my alphabet if I get a point.
Howell,
Jesse Lee Howell.
oh,
He's in custody. Okay, never mind. Then.
who else out there doesn't have an attorney? Okay. Okay.
Your Honor, I also show Mr. Fieser as being one of my clients. He must have been added very recently because he wasn't on the dockets when I checked. Assuming that I am appointed judge, since I just got this case, I would want to enter a denial on Mr. Fieser's behalf and reset him so that I can go speak with him and see if we can try to resolve the case.
No objection, Judge.
I don't seem to have him on my docket, but that's fine with me.
Yeah, he shows as number 24 on my docket, Judge. And he's pro se on yours as well, Deputy? I'm sorry? Okay. Yeah, the docket that we got says that, but either way, if the court wants to appoint us, I represented Mr. Bean, or not Mr. Bean, but Mr. Feaser earlier this year, if the court remembers.
Oh, I have my number, okay, I have on page 3, so I'll appoint the public defender and you enter denial on this arraignment of
Yes, Your Honor.
VOP? Okay,
Yes.
thank you.
Thank you. I'll come see you, Mr. Feaser. I'll see you as soon as I can.
What's the next court date?
Can we do September 5th? I think that's plenty of, just enough time. Is that good for you, Mr. Stiles? September 5th?
And your name, please, sir?
Jesse Howell?
Jesse Howell, okay. You're here on a violation of probation arraignment. Is there any kind of offer from the state?
Judge, I believe this is a sentencing.
Oh, sentencing? I don't have that down for sentencing. Did he admit violation?
Yeah, he's on a VOP. The original charge was grand theft, but he has a new law violation for introduction of contraband. The offer is going to be an adjudication of guilt, $615 court cost, $100 cost of prosecution for the VOP, $1129 Okaloosa County Jail, and revoke and terminate probation.
How much time has he served?
I'm not sure, Judge.
You know how much time you've served?
Right, close to 70 days.
70. Well, I think what I'm going to do is appoint public defender. And I don't want you to enter a plea unless you're really certain that's what you want to do. And he can go over Mr. Williams go over the offer with you, make sure it's correct. I mean, it's something that doesn't hurt you. 'Cause I don't know what your record is. And
It's nothing major. It's my first offense. I was going to try to get a reinstatement and pay my $100 fee to get moved to Georgia.
well, why don't we do this? I'll appoint the public defender. We have a miscellaneous day on, we could bring him back next July 30th or August 8th, whichever one you want.
August 8th was my court date. I'm sorry to interrupt.
August 8th. We'll bring back August 8th and let Mr. Williams check it out. Make sure that if you want to enter this plea and your credit for time served, it's in your best interest or whatever.
I'll look into it, okay?
Yes, sir.
There's also some stuff I need to unpack with you if this is your first offense dealing with your rights and
sir.
what will happen with those with a felony conviction.
Yes, sir.
So, yeah, August 8th will be fine, and I'll have the paperwork and come out and explain everything to you before then.
Yes, sir. Thank you.
Okay? All right, thank you. We have Michael Owen.
Your Honor, I filed a motion on Michael Owens, 19 CF 2090, requesting the court enter an order to transport him here for the 8th for his hearing.
Okay.
Motion to correct sentence, correct sentencing error was filed
Yeah, I read
by
all that.
PD2. And so I was just, set it for today, asking the court in the state if they would agree to a transport order.
I think the issue on that was whether I gave him 1129 or, 29.1 or 12.1. I gave him 12.1.
Yes, sir. No, my client and the attorney that filed the motion focused on particular words that you had said. I got to go with that 12.
That's just an expression.
I know that,
I got to
Your
go
Honor.
with what I think helps him the best
I
in
know
that
that, Your Honor.
situation. But, if they want me to give him 29.1, I'll be happy to consider it instead of 12.1. I'll be happy to consider the 29.1. I'll hear their argument August 8th, I guess.
Do you want me to have him transported, Your Honor?
This state will stipulate to him being transported? Is that what's being asked?
Yes.
Yeah, have him transported.
Thank you, Your Honor.
May want to talk to him about that, too.
Yes, sir.
When I say I got to go with it, I'm just basically saying, in my heart, I got to go with this because I think it's the most favorable to help the defendant between the options I have. Doesn't mean statutorily I got to go with it.
And I understood that.
They know that. They're just playing games, but I'll give him 29.1 if he wants me to change the sentence, or I'll give him the 12.1 that I gave him, because I got to go with, I thought, 12.1. You can relay that to them.
Yes, sir.
But I'm happy to hear their arguments as to why it should be something different, so. Mr. Crawford, if you don't have any other business, you're free to go if you want.
Your Honor, we ran into a little snag on Mr. Curtis Jones. He's currently, the state has agreed to let him plead to possession of controlled substance. We asked him where he lived. He wants to move to Texas. He lives in Texas. That's going to require the $100 transfer fee. The only way that Texas really probably is not going to take him, trying to be honest with the court, because he's just now getting there. If the state would reduce this to a possession of paraphernalia or to a misdemeanor and he were to get 1129, he could be on mail-in supervision and live in the state of Texas.
State is amenable to that, but the court costs are going to be different, so we'll just turn that into a fine.
All right, I'll amend the judgment to be, all right, where is he?
He's out here.
I think the court cost would be
270?
275.
275?
Because if there's a fine involved.
Okay.
No.
All right, so what we're going to do is we're changing that to a misdemeanor. So you're pleading, I'm changing the, you want to enter a plea to possession of paraphernalia, a misdemeanor, instead of felony, which you pled to, correct?
Yes, Your Honor.
Same rights you're waiving and all that, you understand that?
Yes, Your Honor.
And sentencing you to 11.29 months probation. Can be administrative and transferred to Texas.
Yeah, he'll be allowed to mail in his report.
You can mail in.
It doesn't have to be administrative. We can just get him to mail it in, it will come to us.
All right, so he'll be
That
under
way we can keep
probation.
an eye on him.
He'll be under supervision here, so Texas don't have to accept him, right? Is that what's going on? Okay. So that's better, I would think. So
And we would have jurisdiction over him, and that way if he does something wrong, we would be immediately able to contact the court. and let him
yeah,
know.
so they're going to supervise you here instead of transferring it to Texas, okay?
Yes, Your Honor.
And you can move back to Texas after Mr. Berry says you can, and just mail in or whatever he tells you to do from Texas. If it's a felony attack, he thinks Texas won't accept you. So that's what the court's going to do. Was it adjudicate? Withhold adjudication and then the misdemeanor fine instead of the felony fine, 270 or whatever.
The state would be amenable to do 275 for the court cost and then a $100 fine. So that's going to save them like even more.
All right, 275, court cost, $100 fine. Now, don't think because I'm being so soft-hearted and easy on you that gives you permission to go break the law in some way or another. Don't do that, okay?
Oh, no, sir, Your Honor.
All right.
Thank you.
Thank you.
All right, so, Mr. Crawford, you get better and better and better. Okay. Yes,
Morning, Your Honor. Cheryl Gooden for Val.
yeah.
He is here approaching the lectern. We have a signed written plea agreement, if I may approach.
Let me see the attorneys up here.
Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
This is 21 CF 1979, State of Florida versus Fabea Powell. Is that right? Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God. You swear to tell the truth, so help you God?
Answer out loud. Do you swear to tell the truth?
Yeah. Okay. You want to enter a no contest plea charge of use of a computer to lure a child, third-degree felony, travel and use of two-way device to facilitate a felony, a third-degree felony, and travel to meet a child, a minor, a second-degree felony, correct? And the state's going to dismiss count one?
That's correct.
Correct, Your Honor.
So that's, you want to enter a no contest plea to those charges, correct?
You're going to enter those, a no contest plea to the three charges?
Yes.
Traveling to meet a child, use of a computer to lure a child, and use of a computer or a phone to facilitate a felony. Those are the three charges that we're pleading to today. He's asking you if that's what you're doing.
Yes.
You
All
have
right.
to answer out loud.
And the state's going to dismiss one count. So, count one. So, you understand that you're entering a plea to that?
Yes, sir.
No contest plea? Did anyone force you or threaten you to enter this plea?
No.
Are you aware of the rights you're waiving by entering this plea?
Yeah.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No.
Are you happy with your attorney, Ms. Goodson? Are you happy with your attorney?
Yeah.
Work she did? is you realize you're subject to deportation by entering a plea to these charges? You're subject to being deported?
You could be deported,
But I can leave, right?
yes.
Yes.
But you could be deported if they chose to. because of
You
the
understand that?
charges.
You could be deported by being, pleading to these charges? You understand that?
Yeah.
Court finds the plea is freely and voluntarily entered. Court accepts it. Court, let's see, adjudicates you guilty on all three counts. $616 fine. All counts are to run concurrent. You're sentenced on count 2 and 4 to 5 years probation concurrent with each other and concurrent with count 3, which you're sentenced to 10 years sex offender probation. Correct, Ms.
Correct.
Basso?
Your Honor, and there is also on count 3, a 15-year DOC sentence suspended.
At the bottom of the page.
Oh, yeah, okay. And also as a condition of the 15, let's see.
So the 15 years DOC
That is
suspended
running,
conditioned upon successful completion of the 10 years of sex offender probation. And he will require designation.
15-year suspended DOC sentence on count 3. The sex offender designation.
And he'll also require GPS.
GPS monitor, fixed at the lowest rate. All counts are concurrent with each other. Your passport will be returned to you or your brother no later than July 26, 2024. If you depart the United States of America, your probation and cost of supervision will be told, and you will not be required to report to probation, nor will you be violated. Defendant shall provide proof of departing the United States to probation officer and file a copy with the clerk of court. If you return to the United States, you shall report to probation in person within 24 hours of re-entering the United States unless it is on the weekend. Then you report on Monday following the re-entry unless it is a holiday. Standard court costs. And is that it?
I believe the court did announce designation, is that correct?
Yeah, designated sex offender.
And there would be no, as part of that probation, it is a standard condition, but there's going to be no contact with minors.
Yeah, no contact with minors, and
Your Honor, I would ask that it be no unsupervised contact with minors who are blood related. Like his nephew, niece.
so wait, no.
I would ask for no unsupervised contact.
What are their ages?
I don't want his brother to have a child, and in India, the family all live in the same home.
Yeah, I'll do that. No unsupervised contact with minors of his own family.
Thank you, Your Honor.
All right, anything further from, I need a score sheet, I think.
Your Honor, I'll have to file that with the court. I
Correct.
still have the attempted sex bat on there, so I'll have to request
Okay.
that.
All right, well,
The only other thing, Your Honor, is he resides currently in Texas. I spoke with probation previously. Because he's not a resident of Texas, he will have to do his probation in Florida, but they said they would give him a travel pass to go handle whatever business he needs to handle. All of his stuff is in Texas. He can't go get it?
His brother will have to go get it, I presume. You don't want to violate,
Okay.
so. Well,
Your Honor, I would ask that that was our understanding, that he could go to Texas and get his stuff. He can't transfer his probation there, but he
why
could go
can't
get
his
his
brother
stuff.
go get it? Well, Department of Probation says no,
Okay.
so.
If they find him in Texas, he will start doing a 15-year prison sentence
Yes, sir.
because it's suspended, right?
Yes, sir.
Yeah.
Okay.
Don't want to do that, do you? Okay. Yeah, so just basically get that passport and I don't know how you say it in India, but catch a flight. I don't know how you say it in Indian. I think there's 200 different dialects, but if I was you, I'd be getting my passport and heading back to India.
Passport squared away.
Okay?
His intention to.
All right.
Thank you, Your Honor.
All right, thank you. You had no prior record, I presume.
Prior record,
Yeah.
but we waived the PSI.
Okay. Is that correct, Ms. Basso? No prior, okay. Okay, thank you.
Tuesday. Tuesday.
No.
Ms. Rivers, do you want to, you got some cases you want to go with?
I do have one out of custody, Your
All
Honor,
right,
Mr.
Mr.
Guerin.
Gibbs. Okay.
I have another out of custody, but we're waiting on a written plea.
Judge, I've got 3 out of custody that I can call to as well.
Well, who's this gentleman coming up?
This is Mr. Guerin, Judge. Your Honor, Tim Gibbs on behalf of Zacchaeus Guerin. Judge, this is 24 CF 1159. I thought he was on the arraignment docket, but he actually is on this morning's docket. This is a new law violation. I haven't received the state's offer yet, so otherwise I would just enter a not guilty plea and leave this set for pretrial so he and I can discuss.
So at the last court date at arraignment, the defendant was not represented, had a conversation with the defendant, relayed the offer to the defendant. It's a PTI.
Okay.
AutoZone, who is the victim in the case, has entered into a contract with the defendant. So I'm waiting on that contract so I can incorporate it into my
Into the PTI.
PTI.
Okay, yeah, then I'd say we just leave it, if we can just leave it on pretrial so we can get that contract and.
Retrial.
It's a new law violation, Judge yes, it's a new law. He was set for status this morning, as Mr. Sprouse indicated.
You want to go to August 26th?
Yes, for pretrial, Judge. By then, we should have the incorporated contract.
All right. Move it up if you want to.
Absolutely, Judge. If we get
Okay,
it before,
so-
we'll move it up.
Looks like with the PTI, I guess the charges will go away if you do what you agree to do, okay? We'll go over it with Mr. Gibbs, okay?
So give me a call as soon as you can.
August 26th.
Yeah, if you can, it's like first week of August. Thank you, Judge.
Mr. Williams, you had somebody?
I sure do, Judge. Jeffrey Miller. Judge, Mr. Miller was set here after his case was called up on the June pretrial conference date for a plea. He's going to be entering a plea, but he's got some things he wants to finish up first. He'll just be being placed on community control, but he will have a GPS and some other conditions. So what he's asked is we just leave him on the docket for the 26th, and he'll enter a plea when he comes in then and be sentenced.
No objection, Judge.
Okay, we'll do that. August 26th.
Thank you, Judge.
Thank you, Judge.
All right, sir. Jason Kuntz. Judge, the state and defense have been back and forth on offers. We're not going to be able to reach an agreement on this case. I think we had set this case once for trial, and the state had objected to it. So we're just going to be setting it for trial next time. Does the court still want him to come in on the 26th? He does travel from
Birmingham.
Hang on, say I'm duty judge, so I have to check these emergencies and take a break if I need. So I missed the
Yes,
first
sir.
part of what you were saying, and I don't want to.
We're just not going to be able to work this case out. It's going to have to be a trial. There's actually two cases. We'll, of course, try them one at a time. Does the court want him to come back in on the 26th, or does the court want us to maybe set him direct to docket day?
Where is he on the docket?
Hang on a second, Judge.
Could be number 45, I think.
Jason Bryan?
Yes, sir.
Kuntz?
Okay.
Yes, sir.
And Judge, if this is being set for trial, most likely we're also asking for a motion date for a Williams Rule hearing, if possible, prior to the pretrial. I don't know if that's available.
Well, the pretrial is August 26th.
Clerk has a date prior to that, or the court
So
has a
what
date.
about,
I don't think we've got any miscellaneous dates between the 8th and the 26th. At least that's what I was told a few minutes ago, but I could be wrong and actually kind of hope that I am.
Or anything before the trial week, I guess, would work too.
I don't have any dates except for August 8th and July 30th between now and the 26th of August.
Is there anything between the pretrial date and the trial week, maybe? I was just trying to pull
Well, I've got docket day, September 3rd, but I don't want to really do Williams Rule hearing on a docket. I mean, you need to go to trial, so you're ready for trial on docket or plead.
Yes, sir.
Or continue. So,
Looks like there's actually a miscellaneous date on the 5th September.
yeah, I got September 5th.
That would be then after docket day, but before the trial week. That's acceptable.
Judge, I'm going to be here that day anyway,
Mr. Erickman's case, but I'll make sure she's there.
so we can do it on that date.
How many day trial is this going to be, you think? 1 day trial?
Judge, I'm discovering that I'm used to just trying cases faster than everybody else. I put it at a 1 day trial, but depending on who else, it might be more than that. I know
I have
that.
him August 26th for pretrial conference, and then if we don't get it resolved, if you don't get it resolved or whatever, then we'll bring him back on September.
We set the Williams Rule for the 5th?
5th.
That way, if he
so-
hasn't pled by docket day and we are going to trial, we can do that
We'll do
before
that
the trial
then.
week and not delay everybody.
Okay, we'll do that.
Thank you.
Thank you. And just get the notice to me before then.
We'll take care of it. I'll
Okay.
Yeah.
Please.
All right, so. Okay.
Thank you.
All right. And Judge, I have Ontarius McLaughlin.
Is he out of custody?
Yes, sir. Judge, I have spoken with Mr. McLaughlin. He's been good about staying in contact. It's a PTI failout, and we had, worked out what sentence both the state and the defense were going to ask for. I don't know why he's not here. If the court will allow, I'll try to contact him and either get him in for this afternoon or get him in for the 30th or get him in for the 8th.
So the concern is that he's not doing what he's supposed to do. He's not here right now.
No bond capias. No bond capias. He's not taking it serious, I guess. So. All right, Mr. Williams, go ahead.
Judge, that's the last out of custody case that I have.
All these, ladies and gentlemen, just waiting on someone else?
The only other out of custody I have, Judge, is Mr. Bobby Bean. We're waiting to get a written plea printed so that we can review it, sign it, and submit it to the court. If the court would rather not do the written plea and go ahead and get him resolved, it's an 18-month probation deal for the felony driving on a suspended license charge. That was probation.
Where is he?
He's right here, Judge.
Okay.
Oh, I'm sorry.
Come on up. All right, 24 CF 29 State versus Bobby Moore Bean. Mr. Harper, what case are you? You're here for this afternoon, aren't you?
Yes, Judge. It's a quick thing. I can wait until. I was going to ask to continue.
Is this, is it Mosley? Let me, well, as soon as we get through with Mr. Bean here, we'll.
And Judge, I may have had a mistake because my impression was that it was instead for standard probation. The original offer that I received in discovery calls for standard probation for 18 months.
Then we had a conversation via email about that
Yeah, he would have to be on GPS for
Want to
sure.
bring him back July 30th?
That works for me, Judge. I think that's going to be the better way if we ran into this snafu.
Yeah, snafus are July 30th. Come back
We'll call it
July
snafu
30th.
day.
All right, Mr. Harper, come up here for just a, this,
Docket. Mosley.
yeah.
Judge, we had set this for a hearing, but I've confirmed that most of our subpoenas came back unserved for the hearing, 4 out of 6. And so that's problematic from our
Is he
perspective.
transported here?
Judge, he's in custody. He's set for the afternoon, but in that I'm not able to proceed without these witnesses. It'd been my intent to ask to continue it.
You discuss that with him?
I've discussed that with him before and advised him that, if I don't have my subpoenas here, obviously we're going to need to continue
Does
it.
he want to go back to prison, or does he want to stay here?
I think logistically, Judge, it might cause an issue just getting him transported back, and he'd have to come back in because I don't want.
Okay. Continue till when?
If we could have 30 days out, if that's okay with state, I don't know availability-wise. I don't want to conflict with her witness's trial availability here.
It's just Mr. McKinney that I need.
What about September 5th?
We can set that provisionally, and I will verify with Mr. McKinney here in just the next moment and see if he's available that day.
That will be fine, Judge. I will send my subpoenas out again immediately in the event that I did have my private investigator try to serve them again, but
You can go to September 26th if you feel like you need.
I think September 5th is sufficient, Judge.
Okay.
I think that's okay, September 5th. Thank you, Judge, I appreciate that. And Mr. Mosley does not need to be transported this afternoon. Thank you, Judge, that's all I have today.
I just told, oh, I got to tell Cheryl, because we got my staff attorney coming out. Oh, is she here?
Good.
In my office? Oh. Could you contact her and tell her that? Yeah. Okay. Let's do that then.
Your Honor, this is Victoria Palmer. I think she was listed as a no attorney, and then we were appointed just recently. So she's before the court on 23 CF 400, 23 CF 437. Is there an offer?
Yes, the offer is admit, excuse me, the violation, 60 days, Okaloosa County Jail, revoke, terminate, cost of probation.
She would like to take that.
Ms. Palmer, would you please raise your right hand to be sworn? You swear the testimony before this court's true, so help you God. All right, this is 23 CF 400 and 23 CF 437. You want to admit that you violated probation? You understand the rights you're waiving by entering this submission? Has anyone forced you or threatened you to enter this submission? You under the influence of any medication or drugs to prevent you from knowing what you're doing here today?
Not all year, no, sir.
Not
Sir.
what?
No, sir.
She did a rehab program, Your Honor, so she was, letting the court know that by saying I
Okay.
haven't done it.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir, I am.
Court finds the plea is free to leave and voluntarily enter. Court accepts it, revoke and terminate probation. Sentenced to 60 days, Okaloosa County Jail, credit for time served, and was there a fine?
$100 cost of prosecution.
$100 cost of prosecution. Okay? Concurrent on each case. The whole sentence is concurrent on each case. How many days you got in?
I think I'm gonna go home today. At least, it was 45 days last time and like 30 prior.
Okay, well, they won't want to hold you any more than they have to. They don't like people in jail. Okay, thank you.
Thank you, sir. Thank you, Ms. Rivers.
Good luck. Your Honor, Archelius Perry,
Yes.
he has 2 cases, Your Honor.
Okay. Archelius Mendrell Perry. 23 CF 18.
1893, the 24 CF 1552. Your Honor, Ms. Leone is the prosecutor on the case, and she made a new offer for Mr. Perry earlier this week. Mr. Perry made a counteroffer of probation, and he would fight the new case that is set for arraignment this afternoon. And she responded with 3 years probation, batter's intervention.
ECLC program.
Yeah, I have it, I've given it to the state.
Letter of apology to the officer.
Mr. Perry, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Okay.
He wanted a copy of it so he knew what he had to do.
Thank you.
All right, 23 CF 1893 and 24 CF 1552. You want to enter a no contest plea to, is it these charges?
Yes, Your Honor.
All right, in 23 CF 1893, count 1, fleeing, attempting to elude with sirens, a second-degree felony, and in 24 CF 1552, the first one was 23 CF 1893, the second one was 24 CF 1552, felony, battery, a third-degree felony, resisting officer without violence, first-degree misdemeanor, possession of drug equipment, first-degree misdemeanor. So you want to enter a no contest plea to those charges, correct, sir?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes. Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, sends you to 3 years probation on each felony case each case and each count, and they're to run concurrent. No violent contact with the victim. Batter's intervention program, ECLC, or its equivalent.
Yes, Your Honor.
Letter of apology to the officer. And on the misdemeanors, 415 court cost on 23 CF 1893, $100 cost of prosecution, $100 PD fee, $50 PD app fee, waive cost of supervision. And on the next case, 24 CF 1552, 870 court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision, and adjudicated guilty on all cases, all counts. Correct?
Yes, Your Honor.
Okay. Thank you. Yeah, misdemeanors are time served,
Yeah.
concurrent on each.
Your Honor, this is William Reardon before the court on 24 CF 1458. Your Honor, he has a charge of grand theft auto, and he was given a bond of $50,000. The pretrial risk assessment, item 7, checks saying that he had previous felonies. However, CCIS doesn't show him having any prior criminal history or felonies. Mr. Reardon says he doesn't have any felonies, and that he only has, sorry, I misspoke, he has a prior misdemeanor traffic, which is pending now. Mr. Reardon resides in Merritt Island, Florida. He has family down in Merritt Island, Florida. We view his bond as excessive, considering the charge, and he's unable to post any type of monetary bond. He's asking, he says he has major blood clots, that he's previously had a heart attack. I talked to him about ROR bonds or signature bonds with pretrial services, and that's something that he's asking for.
Judge, Mr. Reardon is not here on his own volition. He had to get arrested for him to show up. So the facts of the case are that Mr. Reardon was hired by a friend to help the friend move daughter from Texas. It's like, hey, I need another body to drive this car. Mr. Reardon accepted the money, never returned the car. That was in Texas. So the car was eventually found in Jacksonville, Florida. So Mr. Reardon said, I can't come back to Crestview because I have health conditions. But he drove past Crestview, right past the exit on Crestview, to Jacksonville, Florida. And he also went on a trip to Georgia. So, I mean, the offer is quite minimal.
What judge set the 50,000?
Judge Brown.
The offer is an adjudication of guilt, 515 court costs, credit for time served. The victim is no longer with us, so his friend is passed. But he has an estate who still, has damages from Mr. Reardon, but in...
Well, does he want to enter a plea?
Your Honor, in speaking with him, he does not want to enter a plea. He doesn't want a criminal record. He wants to fight the case. So, that being said...
Was the offer withhold?
It's an adjudication, Judge. He can plead straight up to the bench if he would like. The state's case is pretty strong.
I'll give him a withhold if he wants to plead. That's not a criminal conviction. No conviction.
He wouldn't be a convicted felon. Yeah, Your Honor, one of the issues that I'm running into in speaking with him is I explain everything, and then he responds with he doesn't understand. And I do have a evaluation
Okay, well, let's
pending.
bring you back August 26th. Thank you.
So you're going to come back August 26th. Okay. Yes, please.
Not guilty plea, August 26th.
Request trial by jury.
Could go home today without a felony conviction, but we'll look at it again August 26th. Thank you.
Your Honor, this is Michael Ring. He's before the court for sentencing on 23 CF 13-8. I think it's 18. My glasses broke. I apologize. Your Honor, this was a PTI where he had failed the PTI. He had got referred to Veterans Court, but he was rejected from Veterans Court. So at this point, the only thing that is left is sentencing.
So defendant picked up a new DUI, so clearly not able to follow the and he also failed out of the contract. So we gave him a chance, Judge, so we're going to ask for an adjudication, 120 days, Okaloosa County Jail, with credit for time served, and then standard court cost.
Your Honor, he was given the offer of a PTI. He, to my knowledge, you correct me if I'm wrong, he has no prior felony criminal history. We would ask, and the circumstances, the facts on the case involving this involve the throwing of a throw-up rag on an officer. We would ask and believe
Was that the agreed sentence if he failed on the PTI?
Well, there's no, I don't think there's ever an agreed sentence if they failed on the PTI. There's just the general understanding that the sentence that was originally given as part of the PTI is the sentence that the court usually imposes.
That's what I'll give him.
And that, Your Honor, is probation. With a withhold.
Judge, the state doesn't believe the defendant's going to successfully complete probation on guilty plea. He's going to be back. He clearly has
He's got a new count of DUI, right?
He's got a misdemeanor count of DUI, yes, Your Honor.
In some other with some other judge?
Correct.
Well, state can bring that up in front of that judge, and go for 1129 county jail or whatever. So I'd sentence him to whatever he was supposed to get when he flunked out of PTI.
It was a year of probation. What all did you have to do?
I had community service and
He entered the plea, correct? And I took
Yes,
it?
yes,
All
Your
right,
Honor.
whatever the sentence was, that's what he gets. Okay. And then y'all prosecuting him on a DUI, he can go for a year in jail if that's what y'all want to do. Okay?
Yes, Your Honor. Thank you. So you got to talk to them.
We request the supervision fees be waived on the.
All right. Yes.
Your Honor, this is Bobby Simmons. He's before the court on 22 CF 2132 for violation of probation, and 22 CF, I think it's 2187, violation of probation. We're going to enter denials at this time, and he does have a new law set for this afternoon, if we could handle that now. That is 24 CF 1436, where he's charged with criminal mischief. We're going to enter not guilty and request trial by jury.
All right.
And ask to put it on the regular
You're arraigned
docket.
on that, criminal mischief. They pled not guilty. Jury trial was set you for August 26th, I guess.
And and the state is aware and did correct the problem on your score sheet. But they're not changing their offer. They said the offer remains the same, 12.1. The state's not changing their offer. They did change the score sheet, but they're not changing their offer. We'll talk.
My score sheet's different though.
Right, it's now right at 12.1. We'll talk some more about it.
Can you give these papers to my mom? Or his Simmons?
Mm-hmm.
She's right back there.
Okay.
Can we go back to Ring, because the state sentencing agreement we have only talks about what he needs to do in PTI, not.
Right, and I think that's what the judge is saying is what he was supposed to do in the PTI, which was the 12. Correct.
Okay.
Your Honor, this is Abby Sunday. She's before the court on 24 CF. I think it's 558 and 689. I'll get more glasses during lunch. Your Honor, she is going to enter a plea.
Miss Sunday, Miss Sunday? Miss Sunday, Ms. Sunday, would you please raise your right hand and be sworn? You swear the testimony you give for this course is true, so help you God?
Yes, sir.
Okay. This is 24 CF 558, 24 CF 689, State of Florida versus Abby Sunday. Ms. Sunday, you want to enter an admission to violating probation?
Yes.
Are you aware of the rights you're waiving by entering this admission? Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it, revoke and terminate probation. Sentenced to 11 months, 29 days, Okaloosa County Jail with credit for time served. Enter and complete ECLC, $100 cost prosecution, and $100 PD fee on each case. Each case is to run concurrent. $50 application fee on 24 CF 558. Adjudicated guilty.
That's it?
Thank you.
Your Honor, this is Christopher Whitney. He's before the court on violation of probation on 21 CF 848. We're going to enter a denial at this time.
Okay.
If we could put this on for September 5th.
All right, September 5th. Thank you, sir.
This is the allegations.
Thank you.
Your Honor, this is Alonzo Wilkes. He's before the court on 24 CF 67, I believe. Your Honor, it's a violation of probation. The violation of probation is based on a new law. The new law was dismissed. We are asking for the VOP to be dismissed and he be reinstated back to community control.
I'll look into that.
We would ask to bring him back this afternoon, Your Honor. I believe he should be released today.
Well, just because a new law is dismissed doesn't mean that he didn't violate probation. There's a different standard.
Yeah.
So I'm going to look into it.
All right, we'll bring him back this afternoon and see what the violations are.
I know what the violation is. He was getting arrested for a child support warrant, and he resisted the officers. That's what the allegation is.
Is there any other violations?
No, Your Honor.
There's not.
And I believe probation is recommending reinstatement as well.
Your Honor, Mr. Sprouse is correct. He was being served a child support purge, arrest, and when he resisted and caught the new charge.
So he's going to be in jail anyway. He's the purge. I mean, that's how I understand.
Purge?
It's dismissed.
The purge?
Yeah, the purge is dismissed. I did 30 days for the purge, Your Honor. It was dismissed last week by
Hang on 1 second.
Mr. Charles Hall.
Hang on.
I don't know how Mr. Hall would dismiss a case.
He's confusing the new law.
Yeah. So I'm going to look into it, and we'll come back. I'm not going to be unreasonable.
Bring him back this afternoon.
Thank you, Your Honor.
Okay, thank
We'll
you.
ask for a bond if they don't release you, okay? Okay. I do have one additional one, Your Honor. That would be Patricia Whitaker. She has two cases, 23 CF 1611, 23 CF 1626. We filed a waiver of appearance. Your Honor, we're seeking medical records for Ms. Whitaker. She is in a nursing home. She has previously been declared by the court incompetent. And prior cases were dismissed due to non-restorability.
What do you want, continuance?
No, Your Honor, I'm asking if the court would issue an order for the medical records. We can't get a new evaluation without access to the medical records, and they won't give us access to
Any
the
objection
medical
to
records.
that?
There's no objection, Judge.
All right, well, send me an order.
Thank you, Your Honor.
How many how many Gibb people we got?
I'm sorry, Your Honor.
How many Gibb people we got?
7 inmates, Judge.
I gotta take a break. I
Okay.
got a bunch of warrants waiting.
That's fine, Judge. Thank you.
Okay, I think we got one detention hearing today.
There's 2 on
Two
this.
with their co-defendants.
2? Oh,
Yes,
yeah,
ma'am.
that's right. Okay, we'll take about a 15-minute break.
Very well, Judge. Thank you.
Thank you, Judge.
All rise, please.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Background Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
.1111, 24 CF 1112 tracking. Judge, we're working on getting resolution for him. I'd like to put him to August 8, Judge, for status.
That's no objection.
Okay, August 8th. Thank you.
Your Honor, Tim Gibbs on behalf of Mr. Dennis Brooks. Judge, this is 23 CF 1000, 24 CF 1374. Judge, I'd like to set him for Tuesday. I'm trying to get in touch with the alleged victim on the new case to see how that's going to affect resolution. So I'd like to set it for Tuesday the 30th.
July 30th, thank you.
Thank you.
I have 24 CF 1374 and 23 CF 1000. Thank you.
He's at 1:30 as well.
Yes, not guilty on that new case too, Judge, for the record.
Okay, yes, Raymond, not guilty.
Yeah, that way we can try to get him wrapped up. Mr. Brown was not transported, Your Honor. I had anticipated for other reasons, we may not be able to move forward on his case. Judge, it's 22 CF 1911, 23 CF 2193. He has an arraignment, I believe, this afternoon as well on 24 CF, another 24 CF case, Judge, for an FTA. Judge, we just enter not guilties, denials all around. I'd ask to set him for August 8.
Okay, August 8th, thank you.
Your Honor, Tim Gibbs on behalf of Mr. Dakota Coffee. Judge, this is 23 CF 2767, 23 CF 2768, if I may have just one moment. Judge, we're close to resolving this one. We'll enter denial on these two VOPs and set him for Tuesday as well. I think we can get it resolved by then.
Okay, thank you. July 30th.
July 30th. Thank you, Judge. We're this close. Your Honor, Tim Gibbs on behalf of Mr. Jonathan Corey Davis. Judge, this is 22 CF 2802. We're set here for a status hearing. We are working on a plea. We do have a plea agreement almost completely done for 4 to 5 years DOC for this case. I know that there's a restitution issue. However, I'm not sure if we have gotten a restitution amount. We'd like to go ahead and be able to sentence him, to send him to DOC and bring him back for restitution. I know he also has a Leon County hold for a new law violation or a VOP over there. It's a VOP, right? It's a new law violation over in Leon County. We're just trying to get it resolved. I know it's Ms. Sandler's case.
July 30th.
That's fine with me, Judge. I think we can.
We'll work out the restitution thing.
Yeah, if anything, we'll just do that.
Okay, thank you.
Thank you, Judge.
July 30th.
That's okay. Bring him on out. Oh, is he not here? Yeah. We can bring him back at 1:30. That's fine. Your Honor, Tim Gibbs on behalf of Mr. Jad Franklin. Judge, this is 24 CF 1153. Yeah, he had a misdemeanor. Judge, will enter a not guilty plea, Judge, and leave this set for August 26th for pretrial.
All right, thank you. August 26th. Thank you.
Make sure,
This
yeah.
isn't a ball,
Let me make
because
sure.
I was already sent home.
Make sure you get out. Your Honor, Tim Gibbs on behalf of Mr. Ronald Franklin. Judge, this is 24 CF 1283. Oh, I'm sorry, Mr. Shannon Gallardo. I'm sorry. Moving along. Mr. Shannon Gallardo, Judge, 20 CF 128, 24 CF 545. Judge, I know Mr. Gallardo's wife is present. She is wanting a no contact order modified to no violent contact. These are both violations of probation for a bad UA from June 10th, where it looks like he popped positive for fentanyl and methamphetamine and amphetamine. I don't have an offer from the state yet, but we were hoping to at least try to get him reinstated with no violent contact. I don't know the state's position on that, though.
So he was out on probation on 2 cases and picked up, or not picked up any charges, but and is doing controlled substances. So I think he should do some incarcerative sentence, Judge.
He picked up new charges?
No new charges.
It's just a single bad urinalysis or positive urinalysis, Judge, from June 10th. The results from the analysis, and then later, I believe, confirmed by the lab, were positive for fentanyl, methamphetamine, and amphetamine.
That sounds like a violation of probation, doesn't it?
It's a VOP, Judge. I believe he was getting ready to start his classes at Bridgeway before this violation was filed. So I'm.
Is he entering an admission? Is that what we're doing?
Yeah.
What kind of a sentence are you looking for?
He can plead straight up to the bench, Judge.
Bring him back August 8th.
He does want to admit, Judge, if we can bring him back this afternoon, July 30th or August 8th, I'll leave that to the court.
How long has he been on probation?
About a month or two.
A month or two, and he picked up a
See when his
positive
last-
UA?
Yes, Your Honor.
He's not guilty, I guess, and
Enter a denial for today, Judge.
see if y'all can work it out.
Okay, we shall. We can leave him for the 8th, Judge.
Okay.
So we'll enter denial today. Okay. Your Honor, I do have a Mr. David Ammerman. This is 19 CF 1998. He has been Baker Acted and has been ordered to civil commitment. Under that, he is also not competent to proceed. We're hoping to get the case dismissed without prejudice due to Chapter 916 because it's been almost 5 years and he has now been Baker Acted and is being committed.
Who is that now?
David Ammerman, 19 CF 1998.
So, Judge, the state plans on dismissing the 2 charges based off what my colleagues.
Okay.
However, we're going to do it via paper.
That's fine.
All right, we'll just
What's the control date that you would want?
file it and he'll come off, I guess.
Yeah,
Or
I don't
this
even
week?
think we need it. I just need language.
Okay. If the court, I mean, I'm fine to leave it off docket unless the court wants a
Just leave it
control date.
off and get it dismissed, I guess.
That's fine with me. All right.
Okay.
The reason we don't need a court date is because there's a lot of people involved, and I get emails every other day.
We're both getting bombarded with emails on this, trying to get it resolved, Judge.
I got you. All right.
Thank you, Judge. Is that all my inmates? All right.
Mr. Williams, have you got some more cases?
I do, Judge. Mr. Strauss, I got an email, amended discovery in his POP discovery that has 1129 County Jail with ECLC. Doesn't say anything about credit. My conversation with you was that you wanted him to waive credit. We're not willing to do that. Is the current offer? Excuse me?
How much does he have in?
He's got a fair amount in, I think, but I don't, off the top of my head, I don't know how much credit he's got.
And I'm already in the ECLC dorm.
Yeah, he is already in the ECLC dorm. But he's been working the ECLC even prior to entering this case. He's not coming new.
Yes, I'll waive.
Okay.
Or he doesn't have to waive credit.
All right. All right, let me get your signature up there. That was the only sticking point, Judge. You mind if I date it for you?
Go ahead.
Mr. Hart, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God.
Yes. Can you date that for me?
Yeah.
I supervise Mr. Hart, and I just want to say he looks so much better than he's ever looked. I don't know the last time he's been sober, but he has revealed to me that he really never stopped using, even while he was in jail before. And I just want to say that you look a lot better and look like you're doing a lot better. Your mom looks like she's definitely proud of you.
It's that new spa division we have up in the jail.
739.
Yeah, the ECLC program obviously works, because like I said, I don't think he ever really quit before, even when he was incarcerated. Do what?
The day I got arrested.
Yeah, so.
All right, Mr. Hart, you want to admit that you violated probation?
Yes.
Did you read and sign this plea and sentencing agreement form? Is anyone, you aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams done for you on your case?
I am.
Court finds the admission for the involuntarily entered. Court accepts it. Judge guilty, 11 months, 29 days, Okaloosa County Jail with ECLC and with credit for time served. Send all outstanding
Monetaries to collections, Judge.
monetaries to collections and
I think it'd be $100 cost of prosecution and another 150 PD fees.
150 PD, $100 cost of prosecution, adjudicated, and well, that's it. How much time you got in there already?
Last time and this time, or just this time?
It'd be last time and this time.
About 3 months.
3, okay. All right, thank you.
All right, thank you, Judge.
Marcus Ingram.
Yes, sir.
Judge, we have a signed plea agreement.
Mr. Ingram, would you please raise your right hand to be sworn and swear that testimony you give for us court's true, so help you God? Thank you.
It's a straight-up plea, Judge, so it takes the client to sign.
Straight up. You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission? You aware of the rights
Yes,
you're
sir.
waiving? Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. What is the state looking for on this?
1 second, Judge. I have a least permissible sentence of 15.75 months DOC. So that's what we would be asking for.
What's the defense wanting? Is that a guideline sentence, 15.75?
Yes, sir. Judge, we'd ask that the court impose a county jail sentence, 1129.
How much time has he got in jail?
How much time you figure you have in jail, sir? Not just this time, but every time you've been in court.
About 5 or 6 months.
Why do you want county jail instead of Department of Corrections?
Judge, I don't think anybody wants to go down and get a DC number if they can avoid it.
There's benefits.
It's not true.
There's benefits to
If-
doing 11. If we do 12-1, he's probably going to get out earlier.
In the old days, when the game time was a lot better, yeah, I'd have people asking me in county court if they could somehow or another get a 3.5 state prison sentence, but that was an awful long time ago, Judge, and with the new game time rules.
What's the new game time rules? Is it?
Now, they've got to do at least 85% is the last I recall.
So what was the, how did he violate probation?
My understanding that he didn't do community service hours. Didn't.
No, I just violated by, I didn't take a urinator test.
Any violence?
No, sir.
How much time did he do on probation?
18 months. I come up for early term release next month on the, I'd say 18 months on the 3 years. I'm supposed to come.
I'll do adjudicate 11 months, 29 days county jail. Credit for time served.
Thank you, Judge.
And revoke and terminate. So you don't have to do any more probation, just finish up the jail time.
Okay, so you get credit for all the time you have in, okay?
Mm-hmm.
All righty, sir.
Outstanding monies to collections.
Yep. All right, so just finish up your jail time and don't break the law and you'll be okay.
All right, sir. Good luck to you. I'm doing okay. Judge, Mr. Jackson's got a new law violation coming in for arraignment on August 8th. I'm going to enter a denial for him at this point.
All right.
This is Daniel Jackson,
Daniel Evan Jackson,
23 CF 2806.
Oh, wait a minute. Yeah, Daniel Evan, and then we've got okay, the one I just flipped to was David Jenkins. Yeah, on this one, he's got a new law violation. Have you already filed on it? If so, I'll go ahead and arraign him now.
Well, just making sure that this is the right person. So 23 CF 2806.
That's what I have. You're Daniel
Evan Jackson.
Evan Jackson? Yeah.
There wasn't PC for the new arrests, and that's the only violation that I have. So we're going to dismiss the VOP and we're going to no-pros the new law.
All right, so they're going to null pros and new law violation and dismiss the VOP? Is he serving a sentence on anything else?
Are you announcing that
That's,
now?
I'm announcing that right
Okay.
Okay.
All right, and then are you going to dismiss the VOP, or are you still going to try to?
Yep, yeah, I'm dismissing the VOP as well.
All right, then there's nothing further for you, okay? No, it's as though you weren't violated. You're still on supervision.
Okay.
Do you guys want to talk with him? Okay.
All right, thank you.
Thank you.
All right. Hey, Mr. Jenkins.
How you doing?
Doing all right.
And I'm okay with that offer.
Okay.
1129.
All right. All right, so the state's in agreement with our proposal of just doing 1129 and get you your credit. Is that still what you want to do?
Yes, sir.
Okay. All right, in that case, I need to get your signature right here. There you go. And Judge, this one I had gone through and looked at his credit. He's got about 121 days is what I came up with. I may be off 1 or 2 days. The jail and the clerk will calculate it and give us the official, but it looked to me when I spoke with him that he was at about 121 days.
All right. Jenkins, please raise your right hand to be sworn. You swear the testimony you give before this court is true, so help you God.
Yes, sir.
This is 23 CF 1888, State versus David Jenkins.
Are you Mr. Jenkins?
Yes, sir. Yes, sir.
Okay. You got a score sheet?
No, I don't. I'll get it to the court, though.
Judge State will provide the score sheet later.
You want to admit that you violated probation, Mr. Jenkins?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir, I did.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No,
Are
sir.
you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you 11 months, 29 days, county jail with credit for time served. And do we revoke and terminate probation?
Yes, sir.
Revoke and terminate probation. Just finish up your jail time.
Yes, sir.
Okay, thank you.
Thank you.
All right, thank you, sir.
Money to collections.
What I do now?
Go with them over, or you guys don't need to see him again, do you? Okay.
Thank you.
Just go with them. Judge, Mr. Kulikowski is here for a motion for bond reduction.
What's his current bond?
Judge, he's got $10,500. He's requesting a signature bond on it. He, at this point, is unemployed, but he believes he could become employed again at Little Caesars Pizza. We've had communication from his grandmother. He would be living at 200 Hospital Drive, number 26 in Crestview. 27, I'm sorry. 27 in Crestview. He's got an uncle, a fellow named Charles Adair, that lives in that area, or lives in that apartment. That's actually the same complex that he used to live in. It's just nearby. He's been in this area about 4 years.
If he's found guilty, is he looking at some type of prison sentence?
Well, his score is going to be pretty spectacular because it's a failure to register case. And instead of charging the catch-all statute that covers pretty much every possible way you could fail to register, they filed individually 3 separate counts. And so with the original charge that causes him to have to register, plus the 3 separate counts, all of which I think are level 7s, his guideline score is going to be pretty high. But typically these cases are resolved without a prison sentence unless there's some indication they were trying to do something else wrong. And at this point, there just isn't. I've talked with him about it. He's explained that it's a error in understanding some instructions that he had previously gotten from, was it your parole officer, or did somebody tell you that you were good unless you had a change, I guess? All right, never mind.
He don't understand what you're talking about. So what's the state looking for?
Judge, so the state is trying to resolve this case with a community control sentence, because that's what's required if he's pleads to it. We're not, at this moment, we're not seeking guidelines. The state, offers deals to people who are willing to.
You want to bring him back this afternoon, see if you can work it out?
Judge, I'm good with that. If you want to, what are you looking at in terms of community control? Because my last offer is 80 months state prison.
Okay, so this is his first violation. And at our last court date, it was 6 months community control. So he was to mull over that while he was sitting in jail. So does he want to take that? Or are we going to go to trial, and then I'm going to have to ask for the guidelines?
You want to take...
Oh, thank you. Thank you, Miss Melody.
Okay. Judge, if we want to bring him back this afternoon, I'll draft it up for him.
All right, we'll bring you back this afternoon and plead, okay?
Yes, sir.
Thank you.
Lewis.
You give me some ginger. This is,
Judge, this is Diara Lewis.
Diara Lewis, okay.
When we were in court, she reminded me, when we were in court last time, I think the state had offered 4. Where's?
Or what?
Child Advocacy Center.
Right here.
Oh, I'm sorry, the office.
I'm small, but I'm not that small.
Had offered 4 years. Our discussion by email was 5. I don't know if you remembered that. She's willing to sign off on the 4 years. She does have some credit. I had to look into some other credit that I'm not going to be able to do. So what I've got her at on the case where she has the least amount of credit is 428 days. She's actually spent more time in jail than she spent on supervision.
Very good reasons, actually. But so I'll go honor. She has a 5-year suspended, but if she pleads today, I'll honor the 4 years. I have a new score sheet for that, so that would be below guidelines, Your Honor.
Okay.
She actually has 3 separate cases, and this is her second violation. But supervision's not working.
All right, well.
And Judge, she acknowledges that the supervision's not working for her. We just want to get this behind us.
Mr. Williams, please make sure she knows when she's done, she still has to register.
I have explained that to her. We had a conversation about that either yesterday or the day before when I met with her. All right. Do you mind if I date this for you, ma'am?
Yes, sir.
So who share line for use on.
All right, this is Dyra Lewis, 21 CF 1685, 21 CF 1697, 21 CF 2446. Ms. Lewis, would you please raise your right hand to be sworn? You swear the testimony you give forth is the course of truth, so help you God. Okay. You want to admit that you violated probation in these cases? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, or the admission of violation. It's a concurrent sentence on all cases, and you are judged guilty, sentenced to 4 years Department of Corrections with credit for all time served. Revoke and terminate probation, all monies to collections. And,
Thank you, Judge.
All credit for time served applies to all cases. So when you get out, hopefully it won't be very long. Just make sure you register, okay?
Yes, sir.
So you don't mess up on that. And if you have any questions, make an appointment with the sheriff's office or probation or wherever it is, and make sure you don't, because it's real complicated. Almost anything you do, you got to go tell them about, okay? Like get a car, or if some other car is parked in your driveway, I think you got to tell them there's some other car parked in someone else's car, or even if you move next door or something, you got to tell them, okay? Okay.
Yes, sir.
Any doubt, any question, anything at all, call the registration unit. They would much rather explain it to you than have to do a violation on you and go through all of that.
Okay?
Yes,
Thank
sir.
you.
Thank you.
Michael Manning. Michael Joseph Manning. Okay.
Judge, I've got him, it looks like, I've got two different cases on him.
We're still negotiating this.
Yeah, it's, actually, I was getting him confused with Mr. Jenkins, I guess.
Want to bring him back Thursday?
Well, no, Judge, he's scheduled just for arraignment, so I'm just going to
Oh.
enter a plea of not guilty for him. I don't know why he's on the morning docket.
Okay.
But I'll enter pleas of not guilty for him. Okay, I'm not sure why the morning one was set for, was the morning one a VOP?
No. It's just a status
Okay,
for the morning. And that's the burglary. That
Gotcha.
is actually, the state is going to be amending the charges to not a burglary. We're trying to work out a global resolution.
All right, well, why don't we just, he's plead not guilty and bring him back August 26th, and if you can resolve it, we'll bring you back sooner, August 8th or something like that.
all right, Judge.
Okay?
Okay. All right, sir. Judge, we're here for a bond hearing on Mr. McMurrin.
Okay. What's his current bond?
Judge, right now, he's got a no bond. He picked up another petty theft while he was out on bond, and so his bond was revoked in the, I want to say, probably 3 cases that he had originally, and then, of course, he's got a bond on the new petty theft. His wife, are you guys married or just together?
Planning on getting married.
Okay.
Judge, the amount of cases this defendant has, it's 4, 5. It's for petty theft. He keeps getting out and stealing. We have to give our merchants a break from We gotta keep him in jail until we resolve this and say he can't go back to the place he keeps stealing from.
Yeah, if you're out on bond, you go and allegedly break the law by doing the same thing. I mean, how can I give him a bond? How can I create?
Judge, the reason for the bond is, and the court may recall, he was taken into custody when he came to court last time on the new charges. They were based on a warrant. His fiance, I guess, became very upset, was very loud and virtually hysterical in court. I've since learned why. She advised our office that she had been attacked by a dog and injured. She's unable to work and needs his financial assistance for the family to survive. She's present in court. The court can see her there. She's about in tears. We can take testimony from her and flesh that out a little bit more if the court wants.
No, why does he keep allegedly breaking the law? I mean, I feel bad for her, but you know, they're not even married.
And I had been out on a signature bond for just almost 2 years before I got into any trouble.
No, but was it me that gave him a bond?
I don't recall, Judge. I've had him for quite a while.
Judge, the financial help, it appears, is he's going and stealing. That's the financial help. That can't have that.
Well, that's speculation on the state's part, Judge.
What's his current bond?
Well, currently he's got no bond because bond was revoked on the 3 underlying cases, and what we would be asking for is a signature bond.
That would be wholly inappropriate.
$5,000 cash professional on each count.
All right, Judge.
Thank you, Judge.
So, I can't break it, then you're going to lose the bond money anyway and have to revoke your bond again, I guess. You put up 10% of the 5,000, so you'd put up like $500 per account with a bondsman. But if you're out on bond and you break the law again, allegedly break the law again. I mean, you were on no bond, I gave you a bond, okay? It's reasonable. Thank you.
Mr. Moore.
What's your name, sir?
Moore, sir. William Moore, sir.
Excuse me?
William Moore.
Moore? Okay. William C. Moore?
Yes, sir.
BOP.
Yes, sir. I think we agreed to 6 months.
Okay.
Mr. Moore, would
You
you
get your
please,
signature right
yes,
there.
sir. Right here?
Right there.
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
Thank you. You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this
No,
admission?
sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your
Very
case?
much, sir.
Court finds admissions freely and voluntarily entered. Court accepts it. Is it 6 months county jail?
Yes, sir. 6 months county jail with credit for time served, all outstanding monetary amounts.
6 months
collection.
county jail with credit for time served, all outstanding money requirements to collections. How much time you got?
Sir, I got a month in, I think, maybe 2 months.
All right, well, you'll get credit for that, and you should be out rather quickly, and just don't break the law, okay?
Yes, sir. Thank you very much, sir.
All right, good luck to
Yes, sir.
you.
Thank you, sir.
Judge, the state will provide the score sheet shortly.
Okay.
All right.
Maurice Nitsky. 2 detention. Violation of probation.
Yes, sir. This is the one that's 18, lowest permissible. Will you agree to?
Right.
He's still going to be on probation afterwards because misdemeanor probations are running consecutive.
So I'll review that offer, but right now the state's seeking maximum penalties under this law, which I believe is 5 years of incarceration. So we'll negotiate and see if we can find.
Want to bring him back on August 8th and see if we can get it resolved?
That'll be fine.
Okay, thank you.
We're going to bring you back on August 8th, see if they'll agree to it. If they don't, we'll consider a plea straight up, okay? Okay. Yeah.
Thank you. Thank you, sir. Next.
Okay. Yeah, he needs to come back. It'll actually just take me a few minutes, but I think everybody's probably ready to go to lunch.
Yeah.
So if we can bring him back either for 2 or 1:30, whatever works for you guys.
Speaking of the 2 o'clock docket, Judge, I have Mr. Daniel Arney set for this afternoon. Mr. Dustin Dubrell just filed a written denial and I believe also a notice of appearance for Mr. Arney this morning. I don't know how the court wants to approach that. I would just say to continue it. He's set for an evidentiary hearing.
Correct. So I have no problem continuing the
right.
hearing, Judge, because I'm probably going to work it out with.
We'll continue
Mr.
that.
We may very well be able to, yeah. We were working towards resolution. I don't know what date the court wants. We can send notice to Mr. Durrell.
All right.
I would say later in August 26th.
That's a pretrial day.
Oh.
Yeah, 29th.
Unless the court wants to advise him specifically. But otherwise, with that filing, Judge, I'd also move to withdraw.
Okay, granted.
Thank you, Judge.
Ms. Basso, do we have any hearings this afternoon?
We do, Your Honor. There's the one on Mr. Rivera. I did file a response
Yeah, I saw
yesterday
that.
morning. Do you have the benefit of that, or have an extra
I
copy?
got it.
Okay. That's the only thing. The other one I had, Mr. Mosley, that's been continued by Mr.
Yes.
Harper.
Okay, all right.
I think he has a. No, that's Farnsworth.
Is he on there too?
I won't need Brown.
But you'll need Farnsworth.
Just.
Okay.
All right, we'll continue.
Yeah.
Okay, we'll see you. Ms. Basso, are you doing the 12:30?
I am. I'm doing them both.
Okay.
So